has 2 years for conspiracy to defraud, and he was ordered to compensate government to the tune of 5 billion Uganda shillings. On the other hand, the lawyer may not be directly responsible for the act of corruption, but facilitates or otherwise provides assistance to a principal offender. We have had one case in the Inspectorate of Government where a husband and wife were prosecuted and they were sentenced, both of them. But the act of corruption for which they were sentenced actually took place in the lawyer's chambers, and it was properly recorded, videotaped, and that was the evidence on which the court relied to convict the two. The lawyer can then be an accessory or a principal offender. This is particularly important given the nature of the lawyer's role in the Corrupt Act. If he or she prepares supporting documents to a corrupt transaction instead of making a direct payment to a corrupt person. It is also the position that Rule 10 of the Advocate's Professional Conduct Regulations provides that an advocate shall not use his or her fiduciary relationship with his or her clients to his or her personal advantage, and shall disclose to those clients any personal interest that he or she may have in transactions being conducted on behalf of those clients. In spite of the provisions of Rule 10 of our professional rules, it is known that there are instances where lawyers representing government collude or connive with litigants who sue government seeking compensation. They propose and effect settlements out of court where they will benefit from a share of the court award. Others may consent to judgment being entered in cases where they know that some facts presented by the plaintiff are false. This results in financial loss to government, which is corruption, in the dubious dealings which benefit
on the fines that they're supposed to pay. But because of what I would term long arm legislation from all these foreign companies, where they are coming from, we as lawyers in Uganda, we have to take a step further to ensure that we either put anti-corruption policies within our firms, a reporting mechanism within our firms, so that if one of your legal associates is going to engage in acts of taking loot or worship, then there should be a mechanism. How do I report to the senior partner? If I report this particular associate, is there any way he's going to be reprimanded? Is his employment contract going to be terminated because of that act? That is one way you can do it. Also, some law firms can put in place what we call FAQs, so that if a client is doing a due diligence on your law firm, there are most of these frequently asked questions like what Joel is putting across. Do these lawyers act as conduits of bribes in Uganda? What would be the answer from the managing partner that would be running that law firm? That's my take.
Madam IGG, let me ask you a question that we in the media have asked you umpteen times, and I've seen many of my colleagues, the rumor mongers, are here. You know, the president says journalists are rumor mongers. But a question we have asked you many times, is there political will to deal with this monster? And you see, and well, some people don't like that we make comparisons, but there's countries where corruption is not at our level, and she did adumbrate. She told us countries where, you know, things are not as bad as they are here. I'd like to think it's not because they're very nice, good, holy people. I don't think so. I don't know, maybe, but I'm not too sure that's the case. It's probably because they have made it risky for them to engage in corruption. And one would imagine, I think, that there's got to be will to deal with this thing. Is there a will? The time that you've been in office, you know, you're running into brick walls. You've told us how they're frustrating some of the work that you're doing, but is there a will?
I don't think the question of fighting corruption can be answered by whether there is political will to fight corruption or not. I think we need to understand, and especially it's important for the legal profession to understand, that the battle against corruption is fought in a certain environment. Political is one. Social is another. Economic is another. Cultural is another. So I don't think it is right for us to continue harping on the absence of political will when we have all these laws that have been put in place to fight corruption. What is not happening is the implementation. Ensuring that we implement the laws to maximum capacity to fight this corruption.
We should be implementing.
On the other hand, the government cannot fight corruption alone. We as citizens of Uganda are the ones who know where the corrupt live, are the ones who know which corrupt acts they participate in, are the ones who know what they own and where they started before they owned this. But if we as the citizens of Uganda allow these things to happen and even benefit from them, we cannot continue saying there is no political will to fight corruption. If we are going to fight corruption, we must have the muscle as the people who see the corrupt, as the people who know about their acts, to stand up and be counted. To come to the court, not to make these anonymous complaints where a person writes and says, I know that Minister so-and-so has stolen so much money, and then the complaint is anonymous. So that even we at the Inspectorate of Government or the police or whoever it is cannot follow it up. We have an obligation. Secondly, there is a cultural context. It depends on which kind of, first of all, there's an economic context. Now, if you are in a country where there is poverty, I don't want us to compare Uganda to Sweden or Denmark. Because they are as different as chalk and cheese. Because if you compare Denmark to Uganda, where if I lived in Denmark and I was Danish and I was going to have a baby, I would have maternity leave for 2 years, and even my husband would be paid for 6 months, and I would have a house, and my child has a school to go through too. I don't have to hustle for school fees. The same thing applies for Sweden and Norway and those very rich countries, where there is social support by government, there is housing, there is medical, there is education. All those things have been dealt with. That is not our economic environment here. A person in Uganda has got to fend for themselves. They need a house, they need the school fees, they need to pay medical bills, they need to buy food, plus they have a constituency in the village of cousins, aunties, brothers, and so on, who they have to support. Now, you find that one job supports about 40 people. So when the opportunity to be corrupt comes about, the economic situation will force that person to be corrupt. Then there is the cultural bit of it. Talking about bribery, petty bribery. Once I was asked by an aunt of mine, she said, supposing I do a good job for someone and they get what they wanted, and that person after that comes and says, I'm just giving you kasimo, should I accept the kasimo? And culturally, goats and chickens are accepted. So if a person brings a brown envelope, culturally, it is acceptable. So for you, the legal profession, and me as IGG and the judge will see it as corruption because of Section 2 of the Anti-Corruption Act and Section 26 of the same. But my brother in the village will not see it that way. Then we have, we have that, then we have mainly the social and the cultural. Those are impediments to the fight against corruption when they are put together with poverty. So you cannot say that it is just the politics of the day that is entrenching corruption. Because if you move between these countries that have similar economies, when we sit as anti-corruption agencies, the problems in Uganda are the same as the ones in Kenya and Tanzania and Burundi, although people say Rwanda is different. I don't want to think it is too different. They are almost the same. So I think that this argument of political will or no political will to fight corruption should be put in context in the socio-economic environment that we deal with.
Okay, so clearly our problems are many, but you have had you citizens, you know, you have a role to play also. So you cannot just point your guns at the leaders as thou, for you have no role to play.
Actually, the leaders...
So you refuse...
Elaborate presentation. I also thank the organization for welcoming us here and putting us as panelists in this very contentious issue, corruption. Joel, you said that we don't seem to be doing away with corruption, and you asked why. Like you rightly said, we have a lot of laws in our country, very beautiful laws that state and they state the offenses and as well the penalties. We have these laws written down. So I agree with you that even though we have a lot of laws in place, we don't seem to be fighting the very center of corruption. And I'll tell you this, because we have a lot of institutions that are supposed to do their part as far as fighting corruption, or actually as far as identifying corruption is concerned, as far as investigating corruption is concerned, and prosecution, and also as well as judiciary handling the cases is concerned. So we have many institutions who are supposed to meet their part of the bargain, but we also do realize that not every institution is committed or they do their part as much as they're supposed to do. We heard about the investigations, and her lordship rightly said that sometimes investigations are not done in the way they're supposed to be done. So then that means if investigation is not done the way they're supposed to be done, if these cases come to court, then of course the result is not going to be what we or the public would expect the result to be, because we would expect the result to be a conviction. But if we do not have thorough investigations, if we don't have evidence that is presented to us to warrant a conviction, we cannot do that. And yet at the back of the mind, you might actually be aware that this person in the dock might have actually committed this offense. But you cannot manufacture evidence. It has to be brought to you. So if it's not brought to us as judiciary, you cannot give out a conviction. If that evidence is not given to prosecution, they cannot successfully prosecute these crimes. If it is not identified, because we don't have to firefight, we have to first identify if there are gaps, and if there are gaps that can actually be exploited institutions have policies, but there are also gaps that can actually be exploited that gives birth to corrupt tendencies, that give birth to where money can be siphoned out, where money can be stolen. These are institutions, but we don't have that, we don't have the capacity to first identify that there is a possibility that money can be stolen from here. So if we don't have a system where we can identify, or if the institution that is involved with identifying corruption is not doing their job, then we all fail in this fight, because we must all do our job and do it very diligently and thoroughly for us to fight this corruption mass.
Thank you. Robert, you've been in practice for I don't know how long, but a very blunt question, really. Is it possible for a lawyer, and this is on the backdrop of my interaction with a couple of lawyers, some of them very saved, really born again. They love the Lord, fire spitting, tongue spitting, demon possessed, demon chasing. But they will tell you, man, for me to send my clerk out, they've got to go with an extra envelope. So is it possible, really, practically speaking, in this good country, to practice law effectively, devoid of corrupt tendencies?
Thank you, Joel, and my Lord, thank you so much for the good presentation. Yes, you can practice law without involving yourself in those corrupt tendencies. However, from a lawyer's perspective, maybe as a defense lawyer who has handled some of these cases, there are some of key issues that you must address yourself on. this country runs on the principle of rule of law. Those so-called bad guys have a right to legal representation. And once you have been given instruction to represent them, your duty as a lawyer is to look at what has been disclosed to you by the prosecution. Should you find that the evidence that prosecution intends to rely on is 50-50, what you do as an advocate, your duty is to go and defend that person who is called a bad guy. Because it's also not our duties as lawyers to encourage what I would call prosecutorial incompetence. Most of these cases must be well investigated. Corruption affects all of us. But where you get a matter which is poorly investigated, barely no evidence, but in courts of public opinion, this bad guy has stolen huge sums of money. You can't do much, but you must adhere to the principles of rule of law, fairness, and have this particular person well represented.
Madam IGG, I'm wondering how we can help these good lawyers. Because the reality is, to get a client out of a prison cell, the money has got to exchange hands. Many times for your case file not to disappear or to be, availed quickly to the judge, money has to be availed to the clerk. And all these different things, and they know what I'm talking about. They practice, I don't. I interact with some of them and they tell me these things. How do we help them? And that's not really to, in a way, exculpate them, those that do this. But how do we help them? Because you see, the entire system is problematic.
Now, I will not say helping lawyers. I will say helping the system. Corruption breeds on systems that don't work. Where you have systems that don't work, they leave loopholes through which the corrupt can exploit to carry out these acts of corruption. I remember when we became judges, when we were appointed, we had a training at this very hotel, and we were told by the facilitator that you, as a judge of the High Court, must take charge of your court. And taking charge of your court means take charge of, know what is happening in your registry, first and foremost. You have a registry which is the buzz of the court, the center of the activities of the court. Who is in that registry and how are they doing business in the registry? 2, in the allocation of cases, if you are a judge in a station, take charge. Know what cases are going to, or which cases are the hot potatoes where corruption is likely to happen. Take charge of them. Thirdly, take charge of your court. Take charge of your court in terms of who allocates the dates for hearing of these cases that are brought before you. If you take charge of allocating dates to your cases, you will have blocked one of those areas where small bribes are given to clerks to fix cases for you. In fact, for me, when I was a judge of the High Court, I did not like clerks to fix cases for me because they don't know what is in the case, what it involves, how long it will take to hear it, and how it will be heard, and how many days to allocate to it, and what time the judge will want to hear the case. Because when you sit as a judicial officer, there are times where you feel, I can hear this in such and such a time, or I can better hear this kind of case at this time of the day, so that you take charge of that process as well. But if we leave the courts to be run wholly by the clerks, then we are making them, the registries become cash cows, and those that are corrupt will exploit them. The issue of execution is another one. How is execution happening in the courts? Is there recourse to someone else to prevent abuses in the processes of execution? That is another area where the courts should take charge and assist the litigants to see that where execution is going wrong, it is stopped, and direction given to those who are levying execution. I think that even in government processes, in the ministries, departments, and agencies of government, you saw these cases where large amounts of money was lost. We saw the OPM case, we saw the case in the Ministry of Public Service, the Obeys, the Kasamos, and so on, who have just been convicted. What was wrong there? It was loopholes, processes that allow the corrupt to benefit from the system. So, in order to help lawyers to practice a clean practice, we must also, on the other side, because government is the biggest payer, they have the biggest amount of resources, and everybody fights for cases against government so that when you win, you can be paid. But if the processes in government are not straight and payment can be manipulated, if you look at the recent case where the lawyer was convicted, he also participated in execution because he was one of the purveyors of, court orders to government so that, he has influence and can get these payments done. If we don't get rid of systems like that, where there's a monopoly of some lawyers who are paid faster than other lawyers, if we don't get rid of those syndicates, corruption will continue to prosper. And if we don't stop the monopoly of, because I have heard it said that, you see, in our jurisdiction, recovery from judgment must be done by lawyers and monies must be paid to lawyers. I don't agree with that at all. If we don't stop that, corruption will continue to thrive within the profession because we'll be giving these lawyers arms, we'll be giving them wings to fly away with people's money because we are making people believe that they are the only ones who are capable of following up claims with government and getting payments made to litigants.
Just a quick follow-up, and I'm sorry I'm not putting you on the spot, but when you said we need to stop the syndicates and all these things, how practically can we and should we? We know we must stop them, and so that's the obvious bit. How should we? And you told us you've made some efforts, you've sued the Attorney General. Is there a headway? How do we deal with this elephant in the room, practically?
I have said that it is out of systems. If you have processes and systems that are giving rise to corruption, it is those systems that you attack. You don't attack people. Yesterday I was talking to members of the Judicial Service Commission and talking about a war of attrition. If we started prosecuting every advocate who is involved in corruption, what will happen to the profession? I'm not saying they shouldn't be prosecuted, but I am saying that we should act more to prevent corruption than to have this firefighting exercise where 60 billion has already gone, 15 billion has gone, 29 billion has gone, and then you firefight to recover it, and in most cases you will not recover it. So I'm saying processes in government especially should become more stringent. Those that make payments in government should ensure that they do not support these syndicates being formed where particular advocates are the purveyors of the proceeds of judgments to litigants. I'm sure if you ask lawyers sitting in this room, who are the purveyors, who are the people who are known to be able to recover money from government? It is not every lawyer. There are particular firms, and I am glad to see that we are beginning an attrition on such firms. And I hope that in the future you will break ranks to see that we break these syndicates between lawyers, firms, and government officials to facilitate corruption through legal processes. Because it makes our profession look very bad. We are looking very bad. Everybody looks at us as, Those are the people who are in these syndicates with government for stealing government funds. They facilitate the loss of government funds. We should break ranks.
Okay, Madam Namuno, you're a chief magistrate. I hear there are lawyers who know the law and lawyers who know the judge. And that happens a great deal in practice. Actually, at the level of magistrates, it is not even so much money that we cover these things, we in the media, so I can speak with authority. You know, a magistrate has been arrested for taking a bribe of 100,000, 100K. Some, especially in the village areas, it is a goat, it is, you know, and all these different things. How do we plug these lacunas? Because, you know, that is impeding our fight.
Yes, I've also heard that there are lawyers who know the law and lawyers who know the judge. So I wonder who knows me, but yes, beginning from there, just like everyone says, there is always the good apple and the bad apple in every system. So I cannot rule out the fact that there are probably lawyers who know the law, and there are quite a number of them because they appear before me, and so they're really good lawyers who know the law. As for the lawyers who know the judge, I think that you should turn and know the law instead. Because if you are to handle complex cases like the anti-corruption court cases that we handle, then knowing the judge, especially at the anti-corruption court, might not save you. You should come and argue your case. And so if you bank on the fact that you know the judge, you might be disappointed, and that might also impact on your practice. So I still insist that I would prefer to deal with the lawyers who know the law, and you really made it.
Robert, there is, again, a plethora of rules, and there's mechanisms to try and see that every lawyer plays by the rules. According to the IG's presentation, there's many lawyers who are not playing by the rules. They want to seek justice, but they're not playing fair. I saw Council Byenkya here. He told me, among other things, the maxims of equity. He who seeks equity, and I'm Munyameko, the law and the lecturer to think I didn't understand that one. By the way, Council Byenkya is one of those, he was a tough man, this gentleman, Ash. But he will teach you the law and you will understand. If Byenkya teaches you and you don't understand, go and bathe Chikaji or something. But before you guys go before judges, you're seeking equity, you must do equity. But that's not happening. And I'm wondering, is it because the rules, the mechanisms in place, law council are not tight enough? What is the problem?
I think that's the way you are framing it is not the way it should be.
Well, I'm simply asking.
A reputation for ethical conduct, okay, is a good and priceless asset for any law firm. Now, if you have this client who is going to make you a middleman or an intermediary for corrupt practices, then that is not a client you should have. It begins with you as a lawyer. You need to counsel this particular client. Look, I have a right to represent you. You have a right to pay me retainer fees, but I have an obligation to set. Because I know so many lawyers have done it. They can refuse unethical behaviors from a client. They can. So, bungling up each and everybody as lawyers who practice in these shady ways would not be appropriate. Because I know so many lawyers, so many law firms can refuse to act as conduits of loot. That's the way we used to call it when and corruption. They are there. And you can practice your law without bribing any justice officer as a lawyer. And this one you can quit if, as a law firm, you have put in place anti-bribery and corruption policies. Because now we are dealing with so many international clients. who would want to do a pre-retention due diligence on you because of the nature of the laws that is operating in their countries. I know most of you have heard of what we call the FCPA and the UK Bribery Act. If those international clients are coming into Uganda to do businesses, the first requirement for them to do is due diligence on you law firms. Because the act of a local lawyer will impact those international clients back at home.